different than I expected. Never mind. I need a lawyer.
Hi, I got it.
I took a photo of a rock.
A photo?
Alan, the press is here for me again. Denny Crane, who's your daddy?
No, Danny, this is a potential client.
Don't be selfish, Alan. It's all for me. All for me.
You know, I've heard a lot of crazy things here at Crane, Paul and Schmidt, but a criminal charge taking a photo of a rock, there's got to be something wrong there.
Well, it wasn't just a rock. It was a gorge.
As gorgeous as me?
See, the government just passed this new law that creates special sacred sites for Aboriginals. It allows a group of Aboriginals, once they have proven a special affinity to a site, exclusive rights over that place. It prohibits the taking of photos at any site as well.
So knowing this law, you still took the photo there?
I think my readers should be allowed to know about this.
So you're not here for me?
Shut up, Danny. Continue.
The government asked me to attend a press conference at the Gorge to promote this new legislation and the good work of the Sacred Sites Corporation. We were told what was in the legislation. Section 2 stated that we couldn't take photos of these locations.
No photos?
So you were told not to take photos of the sacred site?
Well, yeah, but I thought there was nobody to be criminally charged for simply taking a photo. All I was doing was showing the public the sincerity of the law and significance of the Aboriginal people.
Well, I don't really know what we can do. The law is the law and you broke it.
Well, it's never stopped us before.
I know that, but I've been investigating this law. I don't think it's valid. How can a law apply to only one race?
Don't question the government. It's unpatriotic. Alan, you can't seriously be considering taking this case.
Danny, someone has to question the government. What have your investigations revealed?
The law might help provide some land rights to the Aboriginals, but it is discriminatory. To be able to get access to these sites, they have to prove a special affinity with the site. And most can't do that.
Well then, it looks like we won't go into court. We have to invalidate this law, or else you won't get off that charge.
You know who we're up against.
Denny Crane.
Denise Bell. You remember my colleague Jerry Espenson? All right. You may be seated. Your Honour, the Commonwealth submits that the defendant is charged with a violation of Section 2 of the Remote Areas Sacred Sites.
Objection. That isn't even a valid law.
Outrageous. Sit down, Mr. Shaw. I'll have no jibber-jabber in this court.
Your Honour, it's not jibber-jabber. It's the main point of the case.
I am the decider.
And you don't want to decide something important?
Don't try to confuse me, Mr. Shaw. I will decide if this law is valid, and subsequently, if Mr. Wilcox will be prosecuted under it.
Thank you, Your Honour.
Sit down.
Denny Crane.
Let me hear why this law isn't valid.
Well, it is submitted by the legislature that the Remote Areas Sacred Site Act is supported by Section 5126 of the Constitution. We submit that this is not the case. Danny, Myers?
Denny Crane.
Yes, this law is not special in that it addresses a real and relevant difference in regards to the Aboriginal people. And furthermore, we'll establish that the Commonwealth Parliament do not deem it necessary, a contentious issue under which we will establish the law's invalidity. Thank you.
And your first point is, Mr. Shaw?
If we move on to our first point, that this law is not special. It may be directed at the Aboriginal people, a requirement established by the Tasmanian Dams case. However, we will establish that this law is not real and relevant in addressing a difference between Aboriginal people and Caucasians. This Act protects land. Okay, what exactly does that mean? A real difference is it a real difference that Aboriginal people are deprived of land? They have the same land rights as anyone else in this country. And to my recollection, the Native Title Act of 1993 exists to grant them special rights to land, and also the decision of Mabo No. 2 in the High Court in 1992 declared native title exists. So what is left for this law to rectify? They have land rights just as we do, and they have more significant land rights given to them by case law and legislation. So we submit that this law is not special in regards to the Aboriginal people.
Objection, Your Honour. This legislation is in place to continue to bridge the gap, which is the continued industrialisation of Aboriginal land, which inhibits their ability to practice their religion and retain their culture. And I think my learned colleague for the plaintiff forgets the decision of the Tasmanian Dam case, where Justice Mason states, "A law which protects the cultural heritage of the Aboriginal race constitutes a special law for the purpose of paragraph 26, because the protection of that cultural heritage meets a special need of that people." So acknowledging the clear disadvantage Aboriginals are at in retaining their culture, this authority applies and the law is special.
Well, for my second point, I think we'd like to submit that this is not a partial repeal of an existing law, it is a new law on a new area in which the Commonwealth is legislating on. And therefore, the Commonwealth Parliament has to deem it necessary under section 5126 of the Constitution, in line with the decision in Cartonieri in the Commonwealth.
How do we know that we know that? I will decide if we know something. I am the decider, Alan Shaw.
Well, historically there has been considerable deference to what the Commonwealth Parliament legislates on, highlighted by the statement in Kawada and Bjelke-Petersen in 1982 by Chief Justice Gibbs. He stated that if Parliament deems it necessary, it can make special laws. However, a contentious decision in the recent case of Cartonieri in the Commonwealth opened up the kind of law enacted under this head of power to debate as to whether it must be beneficial or whether it could be detrimental to the race in question. The separate judgments in this case left over for a brave judge, such as yourself, to decide where this doctrine goes, obviously after a good argument from a sharp lawyer.
I am the decider, Mr. Shaw. All that jibber-jabber is useless. We need clear decisions, and I am the decider. I will give us clear decisions. You fill my courtroom with jibber-jabber. Nonsense. Do you agree with this submission, counsel?
Yes, I think on this point we agree, Your Honour.
Well, I submit the first judgment in Cartonieri needs to be addressed first, that of Justices Gummow and Hayne. They proposed at 378 that a law enacted in manifest abuse of Parliament's power of judgment as to what is deemed necessary is invalid. Now clearly we do not submit that this Remote Area Sacred Sites Act is manifest abuse. How can a law granting the ability to proclaim sacred sites be manifest abuse towards a race? No, what we propose is that this is not a suitable test. It is too broad and encompasses too many detrimental laws which might adversely affect the Aboriginal people.
We also agree on this point. However, in case Your Honour decides to rule this test as valid, I would like to argue that it is not a manifest abuse. For a court to find a law is manifest abuse, it would have to import significant detriments to the entire race. This law provides a substantial benefit of exclusive rights to sacred sites of Aboriginal people. Although some Aboriginals may be unable to establish a special affinity to a site, or to conform to the site's regulations, it is hardly a manifest abuse of the race. I would also like to submit that the manifest abuse test is inherently unstable in reference to Justice Kirby's dissent at page 416. He says, the criterion of manifest abuse is inherently unstable. The experience of racist laws in Germany and South Africa was that of gradually escalating discrimination. By the time stage of manifest abuse is reached, courts have generally lost the capacity to influence or check such laws. Therefore, why, in today's society, would anyone, in light of Australia's history, endorse laws which are detrimental, even slightly, to a person or of any race? Our judiciary should reflect this sentiment by finding that this test does not go far enough and allows too much leeway of Parliament in allowing it to make detrimental laws as long as they are not manifest abuse.
Get to the point. Good arguments, but I'm not getting any younger up here. You need to stop babbling and get to the point.